Hello and welcome to Module 2. I'm your instructor, Annette Harris. During Module 2, you'll be the administrator of the HR inbox in which employees will ask you employment-related questions, and you will be responsible for responding to their inquiries. The Wage and Hour Division has numerous fact sheets that are available for employees and employers. For this module, Fact Sheet 22 and 56B can apply to the HR inbox scenarios. I want to note here that sometimes employees work beyond their scheduled shifts to finish cleaning or to complete paperwork. Sometimes they arrive early to prepare the store for opening, or you may require them to do online training. That time factors into compensable factors for the employee. Determining what counts as work time and what does not is a critical component of your budgeting, your payroll, and of your compliance with federal labor law. So, Fact Sheet 22 is for hours worked under the FLSA. So, what does the FLSA cover? Fact Sheet 22 provides general information concerning what constitutes compensable time under the FLSA. The Act requires that employees must receive at least the minimum wage and may not be employed for more than 40 hours in a week without receiving at least 1.5 times their regular rates of pay for their overtime hours. So, do you have to pay your employees for the time they spend on breaks? The answer to that is yes and no. Rest periods of short duration, usually 20 minutes or less, are common in various industries because they promote the efficiency of the employee and are customarily paid for as working time. These short periods must be counted as hours worked because employees are not completely relieved from their duties. Now you have the meal periods, or typically known as bona fide meal periods. These meal periods typically are for 30 minutes or more and generally need not be compensated as work time. The employee must be completely relieved from duty for the purpose of eating regular meals in order for that time not to be compensable. The employee is not relieved if he or she is required to perform any duties, whether active or inactive, while eating. For example, an employee whose break is interrupted to assist a customer is not relieved from their duty and must be compensated. Now we have Fact Sheet 56B. Fact Sheet 56B is for salaried employees who may be eligible for overtime and provides information about whether penalties paid to employees pursuant to state or local scheduling laws must be included in the regular rate under the FLSA or whether they can be excluded from the regular rate. These laws often apply to retail, hospitality, and or food services establishments, although the coverage requirements of each law varies. So if an employee is paid a fixed salary for each work week and those hours vary up and down from week to week, the employer may use an overtime calculation method authorized in 29 CFR 778.114. This method is called the fixed salary for fluctuating work weeks form of computing overtime. It is easily the most favorable method for employers of computing overtime, but certain requirements do have to be met. So what if you reduce your employees' hours? If reducing your employees' work hours violates their work rights, they could have a wage and hour law case. The government could fine a company or make them pay penalty fees. It's important to ensure that discriminatory factors are not in play when reducing an employee's work hours. Any actions in direct violation of the Fair Labor Standards Act could result in a legal battle. So inform your employee of why their hours will or will not be reduced. So again, all of these resources will be listed in this week's announcement and can guide you in responding to the HR inbox inquiries.